Good afternoon, and welcome to Botnet Takedowns. What happens and how do we improve the process? I'm Stephanie Pell from the Army Cyber Institute. Thank you for braving the weather and coming to our panel. In a moment, I am going to introduce our very distinguished panelists. I, of course, invite you to read all about them on the website. But I'm going to give you a very brief set of opening remarks to kind of orient ourselves to the questions that this panel is going to explore. I will then briefly introduce our panelists. We will then have a very interesting question and answer session, and the very last 15 minutes of the panel, we will open up to audience questions. So, in October of 2016, a massive DDoS attack left much of the internet inaccessible on the East Coast. At first, it was unclear who or what was behind the attack, but it was later determined that the attack was caused by the Mirai botnet. This botnet harnessed internet-connected digital video recorders and other IoT devices to attack Dyn, an internet infrastructure company that provides critical technology services to companies like Twitter, Amazon, Tumblr, Reddit, Spotify, and Netflix. In March of 2011, Microsoft worked with Pfizer, security experts at the University of Washington, and other law enforcement and governmental authorities to shut down the Rustock botnet. At the time, the Rustock botnet was responsible for half of the world's spam. Microsoft coordinated the legal efforts to obtain control of the botnet. As Richard Boscovitz, Assistant General Counsel and head of Microsoft's Digital Crimes Unit, explained to Congress, in June of 2014, the FBI and Microsoft worked together to disrupt the Gameover Zeus botnet, which stole passwords vis-a-vis peer-to-peer technology, making it particularly difficult to track. As explained by former Assistant Attorney General Leslie Caldwell in her testimony to Congress, one common and sinister method used by Gameover Zeus was a man-in-the-middle attack in which victims trying to access websites for purposes of online banking were tricked into entering login credentials, passwords, and other personal information that communicated that information to criminals as it was being passed on to its legitimate destination. Then, with the click of a mouse, the bot masters used the stolen information to rob small businesses, hospitals, and other victims, transferring funds from the victims' accounts to their own accounts. From September of 2011 through May of 2014, Gameover Zeus infected between 500,000 and 1 million computers and caused more than $100 million in financial losses. In one case alone, nearly $7 million was fraudulently transferred from a regional bank. Other victims included an Indian tribe, a corporation operating assisted living facilities, and a composite materials company. Gameover Zeus was also used to install CryptoLocker, which is a type of malware you're probably all familiar with, ransomware, on infected computers. CryptoLocker then enabled criminals to encrypt key files on the infected computers, and victims saw a flash screen on their computer monitors telling them their files were encrypted and that they had 3 days to pay ransom, usually somewhere between $300 and $750, if they wanted to receive the decryption key. To assist in the disruption of Gameover Zeus, Microsoft provided the FBI with technical analysis of the peer-to-peer network and developed a cleaning solution as the FBI and Justice Department took control of the domains and filed criminal charges against the Russian hacker who led the botnet. In his congressional testimony, Mr. Boscovitz noted the important collaboration between the federal government and the private sector in this botnet disruption operation. In her congressional testimony, Assistant Attorney General Caldwell emphasized the importance of private sector cooperation in DOJ anti-botnet operations. Now, I've only mentioned 3 botnets. We are all familiar with many others and the ongoing potential for criminals who control botnets and botnet-infected computers to launch DDoS attacks, steal banking credentials, credit card numbers, login credentials, and other sensitive information. Criminals can use these botnet-infected computers as proxies for the purpose of hiding their own identities and locations as they commit myriad crimes involving fraud, theft of data, and the sexual exploitation of children. This panel will explore how the government and the private sector engage in the process of taking down botnets and how we can improve this public-private partnership. While a majority of these operations have led to successful public safety outcomes, the lack of a more formalized, efficient process that can address a full range of botnet activity and the potential for downstream harms that can occur during the botnet takedown process presents concerns for all parties involved. Moreover, the interests of corporate parties and the government may not always be aligned in these malware interventions. These differences at times could give rise to conflict over the best and most efficient method or path to address both the criminal conduct of the bot herders and the public and safety and information security harms that can metastasize when botnets are not disrupted. This panel will draw on the expertise of high-level practitioners in the public and private sector who are at the helm of these botnet takedown efforts, along with academics who are studying how to improve the botnet takedown process in the context of both current and future kinds of malware infections for the good of all. So let me start by introducing then our distinguished panelists. Again, you can all read more about them on the CyCON website. So in the very middle to my right is Leonard Bailey, who is Special Counsel for the National Security Division in the Criminal Division's Computer Crime and Intellectual Property Section at the U.S. Department of Justice. He has prosecuted computer crimes cases and routinely advised on cybersecurity, searching and seizing electronic evidence, and conducting electronic surveillance. He has managed DOJ cyber policy as a senior counselor to the Assistant Attorney General for the National Security Division, and then as an Associate Deputy Attorney General. To his right is Gabriel Ramsey, who is a partner in the law firm of Crowell and Mooring, and he has been Microsoft's outside counsel on many of these botnet takedown operations. He has significant experience executing proactive strategies to address cybercrime, intellectual property theft and fraud, global enforcement of legal rights, mitigation of legal risk, and deterrence of adversaries. He has developed models for dismantling malicious technical infrastructure through a combination of civil enforcement, extrajudicial technical means, and global collaboration with the government and the private sector. And finally, to my right is Dr. Andrea Matwishin, who is a professor of law and a professor of computer science by courtesy at Northeastern University, where she is co-director of the Center for Law, Innovation, and Creativity. Andrea is a very prolific academic, and her work as an academic and author focuses on technology and information policy and law, particularly information security and cybersecurity, consumer privacy, intellectual property, health, technology, and technology workforce pipeline policy. That's a mouthful. Shows how prolific you are. So I'm going to start with Leonard. Can you give us generally a description of DOJ's botnet efforts, specifically focusing on legal and technical aspects? And how would you describe the goals of these efforts?
Sure. And again, thank you for the invitation to come in and speak. So I guess I'd like to hit 3 points. The first is that the department's approach to botnets has been sort of a sea change in how we approach cyber threats. The use of criminal authority, not to investigate, not to collect information, but to actually dismantle and disrupt criminal infrastructure, to prevent crime, was sort of a new way of approaching the problem. And it started for us in April 2011 with the dismantlement of the Core Flood botnet. That was an operation that was conducted by the FBI and the U.S. Marshal Service, my office, the Computer Crime and Intellectual Property Section, and the U.S. Attorney's Office for the District of Connecticut. Now, Core Flood was malware that stole financial data. It would also drop keystroke logger on the compromised system. And it infected, we estimate, somewhere around 2 million computers worldwide. Now, what we determined was the best approach to dealing with this botnet was this sort of novel use of legal authority, technical operations, and public-private partnership. What I mean by that is starting with sort of the legal and technical aspect of it. We got complaints sworn out under the bank fraud statute, under the wire fraud statute, for the stealing of the financial data that the botnet did, and under the Wiretap Act for the keystroke logger aspect of the malware's activities. We then also got search warrants to seize what were 5 servers that were located in the United States and 29 domain names that were used to route communications of the botnet. We had international aspects, so there was a server, for example, in Estonia that we exercised authority under the Mutual Legal Assistance Treaty to have seized and taken offline, and hats off to the Estonian law enforcement folks because they were dealing with other crises that involved annexation and such at the same time, so, really a tip of the hat to them. And then, sort of maybe the really novel part of this was the obtaining of a temporary restraining order, a TRO, under provisions that hadn't really been used in this way before. So the bank fraud statute, 18 U.S.C. 1345, and the wiretap statute have 18 U.S.C. 2521. They have provisions that allow us to get legal authority to prevent further violations of law under those provisions. And we use that authority, going to a court, to have the communications from the botnet to the command and control servers rerouted, the servers that we had seized. And we had those rerouted to servers that were run by the Internet Systems Consortium, a private organization that stepped forward and was willing to administer the servers that would receive now the botnet's communications. We thought it was best for the government not to be in the long-term business of running this server, and so we handed this off to the ISC. Now, that was an unusual public-private partnership. The second part of an unusual private partnership was that this activity, the kind of cessation of communications between the command and control servers, the ones that were sending commands to the botnet, breaking that channel of communication didn't stop the malware. The malware was still on the computers that had been infected. We also thought there were issues with having the government clean computers around the globe. Some people don't respond kindly to learning that the government has actually accessed their systems and removed something from them. And so we turned to our friends at Microsoft, who had a malicious software removal tool. And the permissions to use that as part of the contract of the user agreement of using Windows, and they helped by taking that step of removing the malware from the system. And ultimately, this was a very, very successful effort. 2 years later, there was something about like a 95% reduction in any beaconing from this botnet. Now, this whole thing became a template for our future operations. But with some variations, and I'll explain what I mean by that in a moment. There were some common themes in all of these activities, you have a network, you have a command node of somewhere, and you are trying to get in the middle of that and break that communication. It seems in most of these instances, we needed the help of the private sector to help us do the malware analysis and figure out what the right strategy was to take down the botnet. And so, over the years, we've done a lot of work with companies, Shadow Server, Dell SecureWorks, CrowdStrike, that have helped us, manage parts of these operations. Now, when I say they're slightly different, and this is point 2, people have asked us, well, why aren't you doing this every week, or at least every month, or more often than you are? And the quick answer we have is that these are not turnkey operations. Each of these operations is in some way different than the one that preceded it. And my best explanation for why is something we were talking about a moment ago. And I will date myself and badge myself as a geek. How many of you are familiar with the Star Trek Next Generation Borg episodes? Okay, yes, awesome. It's likely the best analogy in my mind to what these botnets are and how they operate. So you have this distributed network. You remember these were humans that had, or various organic organisms that had equipment embedded in them that compromised them, made them part of a larger hive mind, right? Much like your botnet. In addition, though, with each generation, they became more resilient. If you attacked them a certain way, they evolved. And that's exactly what has happened over time, and I'll explain that further when I get to Gameover Zeus, which is the best example of that. In addition, to round out the analogy, the core flood botnet, if you recall how they ultimately beat the Borg, Picard had been part of the Borg, so he knew that there was this weakness. There was this sleep command that you could issue, and it would make the whole thing go dormant. Exactly the same thing. There was a sleep command in core flood that we got the authority from the core to issue, and it again made the whole network go dormant. Now, when I talked about the resilience a moment ago, what I meant there is when you fast forward several years, there had been some other botnet activity, takedown activity we've done since then. We helped Microsoft with the Citadel botnet, for example, takedown. But Gameover Zeus was sort of a game changer because of the nature of the botnet and what we had to do with it. So Gameover Zeus was a botnet that we thought infected somewhere around 500,000 to 1 million computers worldwide and cost something like $100 million of fraud loss. It was very different, though, than core flood. Rather than there being some kind of centralized node, it was more of a peer-to-peer structure. It was no longer this central node that we simply take out and we can control everything. It evolved from the earlier forms so that specifically it would be more difficult to disrupt. So we had to come up with a different approach there. Now the malware itself was like core flood in that it was a credential harvesting software that was responsible for being used in connection with various types of fraudulent activity, but it was also a means by which the gentleman who ran the botnet, Evgeny Bogachev, who was a Russian national, was able to load compromised computers with the CryptoLocker ransomware, which turned out to be a very lucrative business for him. We estimate that in 2 months, in 2014, he made something around $27 million based on ransom that was paid through the ransomware scheme. Now, Gameover Zeus required many of the same steps we took with core flood. We again went to the courts. We got authority to reroute communications. We seized domain names that were used in connection with it to achieve the certain rerouting of information. But there are some additional aspects of what we did, including obtaining something called a pen trap order. One thing we wanted to do was collect data, sort of the IP addresses of compromised computers so that we could make notifications through ISPs. Again, another form of public-private partnership getting the actual infected computer owners information that they had in fact been compromised. That required, though, new legal authority because the collection of IP addresses is governed by a particular statute, the Pen Register statute, that renders it illegal unless you have a court order or fall into one of the exceptions to collect dialing, routing, addressing, and signaling information. So that was a kind of a new aspect of the core flood, the Gameover Zeus operation. An additional new wrinkle, and this wasn't the first time we'd done this, but this was the first time I think it had been quite this successful. We, at the same time that we conducted the takedown operation, we also announced publicly the indictment of Mr. Bogachev. And as a Russian national, he was not going to be extradited. Russia does not extradite its citizens. But it was part of the larger disruption effort, recognizing that we could use the public announcement to make Mr. Bogachev radioactive. That is, not only does he know that we know who he is, everyone who would conspire with him knows that we know who he is, which makes it harder for him to do business. So that just that even if we don't lay hands on him, we have disrupted, the way that he operates. We also are very patient. Sometimes people go on vacation, for example, and there's a potential of laying hands on people then. There was a Russian national, Roman Seleznev, a very prolific carder, who was arrested in the Maldives after we indicted him and subsequently sentenced to 27 years incarceration. So there's a path forward potentially at some point, but for now we're in a wait-and-see mode. Only thing I'll add to close this off is the third point is that our challenges with dealing with botnets and the takedowns tends not to be so much legal as technical. There may be legal wrinkles in the future, for example, with the new strains of malware like Mirai that was mentioned that are used specifically for DDoS activities and not for fraudulent activities. There could be a gap in our authorities. And so we've been dependent on sort of bank fraud and wiretapping authorities. Where a botnet's not engaged in those activities, but let's say is dedicated only to attack, we could face a gap, and that would be a legal problem. But more than that, it's sort of staying up with the technical innovations of these botnet coders, figuring out what the next step is and how we can affect our attempt to dismantle them. And that really requires a close partnership with the private sector that we've continued to try to build and maintain. So with that,
thank you. Let me turn to Gabe next. As Microsoft's outside counsel who helped design their legal strategy for their botnet takedown efforts, because while government is often at the helm, private industry is actually sometimes the first player to try and actually come out and engage in a botnet takedown operation. Can you talk a little bit about your work with Microsoft to develop the legal theory and also address kind of the theme that Leonard ended on? What's the hardest part of all this? Is it legal? Is it technical? Or is it maybe even something else?
Right. And first of all, let me just say, so I'm Gabe Ramsey. I'm at an outside law firm, Kroll and Mooring, basically litigation counsel for Microsoft since 13 years now, dealing with this stuff. All the views expressed today are totally my own. All the errors and omissions and all the brilliance is also mine. Not Microsoft's, not my law firm's. So I'll riff on the last point you made. The struggles here, the really hard part, are purely technical. These are operations, and they're different than everything else I've ever done in the law, in the sense that the legal strategies and just even the sort of orientation is all completely driven by architecture. So it's most useful to start thinking about how you're going to design an operation like this, including the law and kind of the rhetoric and the paradigms and the relationships out there with the architecture. Let me get academic for a moment, because I don't very often. Back in the late 90s, a fellow named Larry Lessig wrote a book called Code and Other Laws of Cyberspace, which has, anybody who's ever dealt with the internet, probably if you read this book, the basic takeaway is, law doesn't matter so much as architecture. because that's really what governs norms and relations in technical domains like this. And it's no more, I've never seen a place where it's more true than this environment. So the technical architectural pieces is what you need to understand first, and that drives everything else. And it's true in in one operation to the next, it may be you're simply taking over domains within the United States. That's a very simple case. You may be even using some authority or another to go pull boxes out of the wall in a kind of synchronized fashion within the United States. But what about more complicated architectures like peer-to-peer, where it's a very distributed architecture, it's really resilient, and you just have to get utterly creative about how far you'll go in asking a court to issue relief. So for example, I'll just start to rattle off some interesting things that have happened. Sure, you take down the initial 200 command and control domains, but you know that those million computers are going to default to a pseudo-random algorithm that generates 400,000 fallback domains that are just gobbledygook. In a kind of risk-adjusted way, are we sure it's gobbledygook? Sure. And then we got a court order to preemptively register or control those 400,000 domains. It feels like a really big ask, but at an architectural level, it's the only medicine that would work. And it was a matter of convincing a federal judge that the risk was low enough and the need was high enough. Let it be done. Or the places where infrastructure starts to go outside of the United States. Those are the places where the U.S. government has really some of the strongest tools, because those relationships outside of the United States are formalized. And you can't do everything, but it's a place where the private sector struggles on one hand, in that we don't have formalized relationships. But at the same time, that's also our superpower. We're not state actors. We have all this sort of flexibility to just go knocking on doors and asking for help under the table, if you will. And it's surprisingly successful. There's legal limitations, but folks will help and be fellow travels with you in the private sector in ways that are perceived and probably feel quieter than if they're engaging with government. And you can get a lot done that way. So that's kind of there's some pros and cons in terms of structure and kind of fluidity in the tool set. And nimbleness, just you can act really quickly as a private sector actor in a way I think governments can't always do, for good or bad. And I think that's going to be a topic we talk about, is balancing equities in this environment. But I mean, I've had situations where in some of the operations along the way where the technical team at Microsoft is watching the infrastructure, the command and control infrastructure of a botnet move over time and space, and it's a moment where it's like, okay, wait, those 250 domains controlling 1 million boxes are now all located on US TLDs. And we literally hop on a plane, we're writing the brief on the plane, you land someplace, and you physically walk it into court. And we can just do that. We don't have to seek approval. And that's really powerful and intoxicating. And as a dumb young lawyer, it was super, super exciting. But as that process has matured and more stakeholders become involved in it, there's a lot more to it than that. And you got to balance the way you're working with other partners and other stakeholders and equities, and not just race off and do things. But it can be very powerful. I'm going to posit why I think that nimbleness and agility and speed is powerful. And this is the philosophy to me, is that the internet is not governed, right? The internet is a random ad hoc series of nodes that evolve over time. We all probably know something about its history, where it's just loosely coupled together through contract. And that's a really difficult domain in which to exert control. So the mere sort of notion of speed and agility and just looseness at tackling this type of this sort of abuse in this domain kind of joins in my view, sort of joins directly the way that the internet is not governed, right? Like all that sort of chaos is exactly what the adversary leverages. And so if you join it in a way, and it's not perfect, it's not the perfect being the enemy of good, it's really just leveling the cost asymmetry between adversary and victim, where all we're trying to do is increase your cost in some basic way at speed and at scale, in some way that meets the basic mesh of the internet, the way that it's structured or not structured. And I like that. I'd hate to lose that if we could look for two structured solutions in this domain. And as a private sector actor, I get to do more of that. I get to kind of fulfill that impulse a little bit. So that's one observation. I guess I'll just end with, there's some practical observations about architecture, but at least in my domain, there are no gaps in the law. The civil law is so broad and flexible. I have I may have a law about computer intrusion, like Computer Fraud and Abuse Act, that's very specific, and I can deploy it for this piece of an operation, and I may have a trademark abuse in here, and I can deploy the trademark law of Microsoft's or some other company's brands being abused. But I have all this common law sort of underpinnings that I can fall back to if there's a law that doesn't exactly fit. Things like unjust enrichment. What does that mean? It means you took a benefit that's kind of disproportionate to the cost to me or my client. And you can fill gaps with things like that, or common law trespass or conversion. Hundreds of year-old English law employed in this domain. I just have a lot of gap fillers that I don't feel like in the criminal domain you necessarily have. So that's kind of the landscape in which I operate, and I'll leave it there.
Thank you. So Andrea, you've done some very interesting work on what you've called the Internet of Bodies, or IOB. And I will allow you to explain to our audience what you mean by IOB. And at first glance, a discussion of the Internet of Bodies may not seem to fit with our botnet takedown focus for today. But I sense that, like Cassandra in Greek mythology, you are here to warn us of the coming of botnets of body parts.
And I hope I'm completely wrong on that, by the way. Following up on the excellent commentary of my co-panelists, what we see is that there is a fluidity between the private and public sector aspects of the attacks that we're seeing, particularly when it comes to botnets. So I've called this the problem of reciprocal security vulnerability, that you can't limit the analysis of security vulnerability to either one sector or another in order to actually solve or attempt to address the problems of security vulnerability. So this concept of the Internet of Bodies is really the next generation of the Internet of Things. And it sounds sort of Borgish and sci-fi, but when you look at the types of innovation that already exist in the marketplace, what you see is that we frequently have little devices attached to our bodies externally in a first generation of the Internet of Bodies, things like Fitbits, fitness monitors, smartwatches, and factory settings, we have smart glasses. Now we're seeing an increase in the second generation of these Internet of Bodies technologies, which are embedded inside the body. So some companies are starting to, for example, chip their employees for purposes of convenience, helping to unlock computers in the workplace or buy smoothies, or some people like to carry their cryptocurrency wallets embedded in their bodies, for example. So we see this progression where the body is melding with other technologies. And of course, the primary variable that will unfortunately transfer from the Internet of Things is vulnerability. And so imagine the world of the Mirai botnet happening not on DVRs and webcams, but instead on the already FDA-approved digital pills or the artificial pancreases that are embedded partially in human bodies. And so these next generations of innovation that are body embedded, and then the third stage will be potentially body melded, things like Elon Musk's neural lace or the brain bypass technologies that exist in clinical trials and medical contexts, where there's a merger of external content and internal human body hardware and software. You start to think through the potential for the human body becoming part of the hardware of botnets. And so that puts another very complicated wrinkle onto this set of shifting structures that need to be considered by the private and public sector actors who are working together in order to mitigate the harms from these botnets. But I would like to respectfully push back on something that both of my co-panelists mentioned. I think they're both underestimating the importance of their own skill sets in helping to construct the particular methods that are most appropriate for those architecturally complex scenarios. And so one of the things that, as an outsider, I worry about is that the skill sets that experts such as yourselves have spent an entire career building be captured in a way that others who come after you, who don't necessarily have your idiosyncratic and expansive experiences watching the internet develop, that those lessons are captured and passed on in a way that's historically documented. One of the deficits that I think we are living with right now, because we're so busy building and trying to mitigate security issues, that we're not documenting our own history in this era of security of the internet, and that we are therefore not necessarily extracting the full extent of lessons for the future that we might be able to glean from the incidents that we successfully handle, and consequently pass on these lessons to the next generation of defenders of our technologies. So I'm sure we'll get into additional conversation on this, but those are some opening thoughts.
So let me direct the next question to both Gabe and Leonard. While it is generally in the interests of both the private sector and of the government to disrupt botnets, and indeed you've both explained the public-private partnership that has developed over the years for these purposes, are there times when government and industry interests may not be perfectly aligned at that moment in time? In other words, what would happen, for the sake of argument, if the government, to better build a case against the bot herders or other criminal actors, wants to continue to collect evidence, and private industry says, wait a minute, this is harming us in several different ways. We want to proceed with taking this botnet down. How should those equities be balanced?
You want to lead off?
Why not? So I actually don't think...
Be gentle.
Okay. I actually think that those sorts of collisions, while possible, are one, increasingly unlikely for the following reason. One of the things that I think the government certainly has embraced in at least the last 5 years is the notion that we don't want victims to be victimized again. And so if, for example, we came into an instance where we were coordinating some sort of botnet takedown and some, or I should say the other opposite direction, that the private sector were coordinating some botnet takedown and we learned of it. The approach, if there were an ongoing harm, wouldn't be, no, you should let that continue. It would be, well, let's coordinate and figure out how we can stop the harm while preserving whatever equities we may need to move forward. Now, this does start moving into kind of a tricky area, which is one of the things that Gabe drew attention to was the fact that the private sector is different than the government and has certain latitude to do things that we don't as a government actor under the Fourth Amendment, for example. I think there's been some caution on both sides, but certainly on the private sector side, about not being so intermeshed with the government that they become state actors, and there are consequences to that. And so there's, I think, a friendly and I think cooperative arm's length relationship on a lot of this that leans towards coordination of effort with a common goal of saying these are bad and we want to eliminate them with as quickly as we can, but with some respectful distance on how we actually proceed.
Yeah. I'll kind of answer the question at two levels. So the kind of down on the street granular level, yeah, there have definitely been times in operations that I've been involved in where I think acts that were authorized by court order or otherwise bumped up against things that the government was doing in ways that I wish had not happened. And I'll give you one example that I'm generally aware of. It was one of the botnet cases, I won't mention which one, where we took down a bunch of infrastructure, and that part was fine. I mean, maybe the government was investigating the infrastructure, but that wasn't really the thing that was an issue. After that happens, I have an obligation to use the butter knife of civil discovery to at least try to identify the defendants, because there's some civil rules around them, at least attempting to do that, even if it's going to be a little bit difficult. And I ended up sending, butter knife civil subpoenas to a couple of Gmail accounts that I think were wiretapped, and that was not. It disrupted a government operation that was very specific, and I didn't feel great about that. But there's a lot more since the time that happened. There's a lot more coordination between me and the companies that I work for in government to make sure that generally that's not going to happen. So it is a risk. So now I would take it up a little, it's kind of out of the street. I completely agree with the characterization. Respectful arm's length, kind of negotiation is the way that it works best, I think. I'm going to be real candid. There's control of this problem set is highly politicized, and I hate that. Everybody wants to be the owner of the solution set because they're funded to do so and they're incentivized to do so, and they get credit in their domain for doing so. Whether you're a cybersecurity company or the Department of Defense or the Federal Bureau of Investigation or me. And part of that arm's length negotiation is negotiating past the politicization of I'm the owner and keeper of the solution set. Because if any one constituent sort of has their way, a whole bunch of equities get pushed to the side, and that's unhealthy. So one takeaway, and I'm kind of I think segueing to a topic we're going to come a little later, is I like the fluidity of the negotiation with the government. I like kind of coming to the government and saying, we're going to do this thing. It's coming. Are you going to get a quarter to stop us if you're saying no? And if you're saying no, convince me that I can trust you and that you really mean it and you have a really good reason. Don't just do we're the government, we got it thing. Because it's not going to be well received, and over time, trust will be reduced. Because I don't want to serve subpoenas on Gmail accounts that are wiretapped or otherwise interfere with a valid law enforcement activity or other government activity. So this kind of long negotiation, even if it's a little awkward sometimes, is super healthy. And I see more of that over the last 5 to 10 years than before, and I hope it continues.
So let me preface this next question to Andrea with an observation, at least that I've read about, that while everyone has acted in good faith on Microsoft's part, there have been some mistakes along the way in terms of legitimate traffic or other aspects of architecture shut down that certainly weren't intended. Is that a fair characterization?
Yeah, it's definitely happened. I think relative rarity, but it has. I mean, these are experiments at some level.
So, Andrea, in your view, thinking about probably the need for ongoing botnet takedown operations, should we be thinking about how the law should address potential downstream harms with the understanding that, Microsoft and the government has a deep track record, but there could other companies could certainly, the law would allow them to engage in these efforts. How should the law consider the possibility of downstream harms if there isn't already adequate remedies or foresight?
So as you've identified, the possibility that other actors, perhaps with less sophisticated knowledge of the nuance compared to the two experts that we have discussing with us today, as new players start to enter this complex set of relationships, it's possible that differing levels of care will be applied by those actors. And for this reason, I think that to the extent we can help formalize some of the successful processes that have already been demonstrated to work, and to identify those lessons that I was speaking about earlier as both positive, potentially effective strategies and as suboptimal or higher risk strategies, those kinds of lessons that repeat players can share, a more formalized process may help to transfer that knowledge to new entrants who may not necessarily have the same positive consumer protection or social motivation as DOJ or Microsoft have in this case. There's always the risk that civil liberties groups will raise, for example, that an overzealous IP holder might try to leverage this not for the benefit of a defensive maneuver to protect consumers, but instead as a sword, and that the sword may end up causing more damage than it remediates. And if we're talking about, for example, some ransomware that exists on a body-connected device, or say an exoskeleton with an internet connection, which is something that both private and public sector R&D is engaged with, you have these other equities that fall into this analysis that make the situation more complex. We also have different governmental players who haven't yet engaged with these questions. For example, when you look at the way that the spread of malware and botnet enabling code permeates the system, it starts to look a lot like some of the epidemic properties of disease. And CDC, for example, has not really engaged with these issues yet. But yet it's a natural next participant. For example, the FDA is worried about security of medical devices, but not all of the technologies that I'm talking about in this Internet of Body space will fall under the FDA and their own self-determination of what constitutes a medical device. So that means that there are some regulatory gaps, some perhaps uncoordinated areas that may require some next generation approaches to ensure that the technologies that exist in the world don't fall through the cracks of the proactive mitigations in security that could prevent a portion of the botnets that we're talking about here today as well. So there's both this historical retrospective analysis with a little more structure, and there are these proactive approaches that we haven't yet engaged with fully as a society.
Could I just a quick couple of things on that? I think there might be some guardrails, hopefully, that keep us on the straight and narrow. I think I know one response to this, but hopefully courts help us a little bit on this, in that for most of the activity that be required to take down a botnet, you have to go to someone and tell them to do something. So you're going to a company and saying, block this. Most of those companies are rather risk averse and are not simply going to say yes, but they'll want to know what's your authority, which means you had to have gone to a court and filed something and convinced a judge, which may be the weak link sometimes, that this is appropriate and has been correctly vetted as activity should occur. If that works properly, you have at least that one guardrail. The second thing that I think goes to a point that you made earlier, Andrea, which I think is right, that knowledge management is something that the government does very badly. We often lose the thread of information that has been garnered someplace else. One thing, though, that has happened in this type of operation for us is we've tried to be very, very transparent, and that is with every single one of these botnets, we have posted, published all the orders, all the pleadings that were used to get the authority to do this. And that has two consequences. So the reason why we're doing it is, some people will react, instinctively very, in a rather shocked, protective manner when they hear that the government is dismantling parts of networks that are out there, even if they're for criminal purposes. I think we've managed to actually assuage concerns that would otherwise be out there if people could not look at exactly what we've done, how we've done it, what authority we had, so much so that publications that normally would bash us in the head for doing activities like this have said things like "attaboy" and you've done a good job in round one. But the other consequence is that there hopefully is some record out in the world so people understand how these things are done, how they have been done, and maybe how they should be done. And maybe that will help.
I think it certainly does. I'll just comment, pulling on one of Gabe's threads about contract law. So one of the kind of parallel sets of problems is the slippage of contract law in digital spaces. And so one of the things that concerns me is that as the contracts that govern user relationships with companies become progressively more draconian over time, shifting more responsibility onto users and becoming progressively less understandable, which if you track them across time, if you look at end user license agreements in 1999 and you look at an end user license agreement today, you will be able to see that shift very clearly. And so contract law in some ways is becoming a less potent force in helping to structure the freewheeling space of the internet. And so the counterbalance that we have traditionally had, which I think is a fair point, I'm worried that it's diminishing as a valid counterbalance, which then increasingly gives companies the easy out of just sharing any information that they want with or without court order, or cooperating in ways that are minimally annoying to them to minimize their own transaction costs, rather than thinking about the interests of their users, expecting contract law to shield them from any liability for hasty decisions made in the course of their corporate conduct.
Can I just tack on a couple of thoughts there? So one about the kind of guardrails aspect. Once a takedown happens, it's certainly true in the civil litigation environment, the game's not over. If you cause injury at that point, so first of all, to get the order in the first place, you have to post a bond. You've got to put money up to say, if something goes sideways here in any material respect, then we're back here in 2 weeks, and there's a lot of collateral damage, and somebody wants to come to court, judge, I am dead in the crosshairs, and that's my obligation. So that keeps at least in my world, keeps me in check, because there's skin in the game, it's like, if there were something that really went sideways, you would find folks in court arguing 2 weeks later, taking that money, or otherwise getting relief. So I think that gets lost. That there's really process for all those third parties. I'm not sure that's always comprehended. And then on the sort of institutional knowledge, definitely publicizing all these things that happen. They start out ex parte usually. There's a secret component that wouldn't work well otherwise. But then all the documentation is out there. I think, kind of back to my politicization point, if we can kind of get beyond the politicization of the solution set, it will be, that will be kind of an incentive structure for all the smart stakeholders to start to keep and sustain the knowledge of how you start to solve these problems, rather than reinventing the wheel and holding it close. Because, I'll be candid. I'm not authorized to speak publicly about this stuff very often. It's sensitive, it's careful, it's difficult for governments to do that. But the more we can kind of get comfortable doing that, the more likely we are to sort of hold and build on the collective knowledge. Yeah. And hopefully that happens.
So this is kind of got a few more minutes before we're going to open the questions up to the audience. But we've talked significantly about the difference between public and private sector, and the appropriate limitations on the government in certain aspects, and perhaps a more freewheeling atmosphere for the private sector. But nevertheless, you have to work together. If you could change anything to improve that partnership, because I think we're all in agreement that botnets as a threat to cybersecurity, potentially to physical safety, are not going away. If you were, I'll use the words of Greg Conti on a prior panel, if you were kings for a day, queen for a day, what would you change, either about the law or about the working relationship between the public and private sector?
I think, from my point of view, more transparency from government about what they really need. Like, okay. when just being able to better assess if I'm being asked to stand down, can I trust you? It's just that, and I don't know how we get there, but that, to me, that is my biggest hurdle right now.
And is it fair to say, without naming specific examples, that you've felt like at certain times that trust has been lacking?
Yeah. I think of it more. It's there's some folks in government with whom I've been engaged who are really risk averse, in the sense that there might be an effort, an investigation or something underway that's just nascent, and it's just safer to say, just don't touch anything here, even though it's not so well developed. Perhaps I learn later it's not so well developed, and if we'd had a more honest kind of transaction and conversation at that initial moment, we might have perfectly well, over some shorter time frame, gotten to a well-balanced approach together. And it just doesn't always happen, but it happens more and more, in a more productive way with more and more frequency, I've noted. And so I'm very hopeful about the way that plays out.
So one of the things I love about this area is it is marvelously complex. And one thing that we have been working on, and I know Andrew's well aware of this, for the last few years, is building a better relationship with the security research community, who at points were scared of us because of fears that we would go after them for doing certain types of research. And the thing that is, I think, painfully apparent to all of us in law enforcement these days is that there is great value to things that community does, such that I've seen recently in FBI presentations that pen testing is listed as something they recommend that people go out and do. I say all that to say that I think one of the biggest problems here for us is getting, again, on the technical side, the information, the strategy, knowing how to attack the problem with each different problem set. And so getting a better exchange of information among the research community and law enforcement so that we can use our tools and authorities, which they lack, but the knowledge that they have to better attack the problem.
So building on those two excellent sets of comments that resonate with me as well, I think there are at least two concrete strategies that would help to further smooth cooperation and also efficacy of future takedowns. The first is, following up on Leonard's comments, the engagement with security researchers can be a fruitful pathway, but in particular, one of the obstacles to security research is the perceived ambiguity in the Computer Fraud and Abuse Act language. So the Act focuses on authorized access, which is a legal term of art that doesn't map tightly onto technical concepts, which means that security researchers don't always have the ability, and their counsel doesn't have the ability to anticipate fully what kinds of research may transgress into unauthorized conduct. So reworking the Computer Fraud and Abuse Act, which was a good try for the 1980s, but we have a significantly different technology environment at this point, and so an update to that statute would definitely help. The second concrete strategy that might be of assistance is to inject with court oversight a technical expert that both sides, the private and the public sector, agree upon to act as kind of an honest broker and a nudge to help resolve those conflicts and provide meaningful technical input on possible strategies for greater efficacy in particular situations with botnet takedowns in light of the unique architectural constraints of the particular piece of malware at issue. So those are two concrete strategies that might help.
Great. Well, we have about 16 minutes left, so love to open the questions up to the audience.
Hi, my name is Patrick Maldre. I'm threat intel analyst at a small startup called CyberCube. Thank you for a very interesting panel. I enjoyed hearing about the historical examples and the legal environment and the challenges and opportunities of public-private cooperation. I'm curious, I imagine especially our practitioners on the left from my perspective can't speak to current operations, but I'll frame the question in a different way. If you had a wish list of a couple of botnets to take down right now, which are they and how would you go about doing it?
So, I mean, I'm actually not going to name any specific ones, but I will say this. I mean, because there's a list of them that you can find anywhere that's fairly static. You know, this goes to the point I was raising earlier about the how do you take them down. I wish I could tell you exactly how we could take them down. The complexity of this, as I was saying earlier, is tremendous when you cross particularly international borders, right? So a lot of the authority we have in the criminal land, and actually in civil as well, is bounded by our territories. And so there are things that we can do that are dramatic, that are here, that may do with things like, you know, going after registries and domain names that are here that we could exercise some sort of court authority over. It is harder once you get past our borders. And you know, it is a long game effort in our land to build better relationships with a number of countries so that, you know, we are better at this. We have, you know, not just mutual legal assistance treaties, we have something called 24/7 network with a number of countries, so we have informal assistance. You know, but I think if there's some nut that really needs to be cracked, it has to do with the international reach of these networks and how we tackle that. It also presents various issues that I imagine people in this room are well aware of that involve offensive operations and the perception that, you know, you have now interacted with computers in a foreign country in ways that a sovereign there may not, you know, approve of. So anyway.
Yeah, from my point of view, I'm not going to name particular botnets either, but I will say from the kind of vindicator of company rights, there's always, you know, there's a perpetual flow of financial theft malware that's well funded and well scaled because it's the most lucrative sort of operations to invest in if you want to make money from cybercrime. So there's a couple of families out there of financial malware that are pretty you know, relatively new, last couple of years, that are quite scaled, that I think are getting a lot of attention. And there's always a couple of spam bots, not because spam is interesting, just because it's this is capacity to do other bad things. So from my point of view, those are the things that I'm staring at more frequently than the low and slow APT stuff that the Greater Washington, D.C. area thinks about. I think about that stuff less.
One follow-on comment, agreeing with everything that was just said. There have been increased press reports of botnets that are funded by foreign governments. And so from a hybrid warfare perspective, a foreign government-funded botnet, particularly once we start to creep into the ability to cause physical harm to civilian populations, that's something that worries me greatly.
Bryson Board, actually, you just led up to my question there. So when we look at botnets, this isn't something that's abstract because this is also something that's in our homes because of the increased interconnectivity and use of IoT. Mm-hmm. So if you were king or queen for a day, what's a solution that you would bring to the table that handles the fact that the folks who primarily own that aren't even aware of the threat, let alone care?
So one sort of light touch first step would be for the Consumer Product Safety Commission to engage with guidance on baselines of safety in terms of the software, the results, the potential safety harms of software in IoT in the same way that they engage with the physical harms of, say, a chainsaw. Believe it or not, there are now saws that have an app for your phone. And all of those devices are, of course, vulnerable. So this is a civil problem and a consumer protection agency problem as well. So these kinds of incremental approaches across agencies collaboratively can push us all forward. And CPSC did have the first round of hearings on IoT safety as a possible lead up to rulemaking or guidance or engagement. So there's starting to be motion in those directions, but the faster the better, as far as I'm concerned, particularly because of botnets.
And so I'm a knuckle-dragging prosecutor, so this is a little bit out of my lane, but I do think that we have a complicated problem with IoT where the incentives are entirely misaligned, right? So essentially, producers of these devices are built on bold measures. They look to bring something to market as quickly as possible that is as user-friendly as they can at the lowest price point. And indeed, if you're competing against them, building security in, which usually requires more time, so slower to market, and more care, maybe a more expensive product, that is not a winning combination for someone who is going to bake security in. So, I mean, I think building on what Andrew was saying, I think there are various things that are not necessarily regulatory, but standard setting and other things that would have to go to leveling the playing field so that security becomes necessarily a component that is part of the out-of-the-box product.
Yeah, and it would be professional suicide if I advocate any form of regulation in any domain of technology. But I will say standard setting and kind of standard setting in a particular way. A lot of these devices are really low cost. You kind of alluded to this, low cost and sort of low investment software platforms in order to actually make money off of for the private sector. So from their point of view, the security solutions have to be can outweigh the sort of margin that you're going to get on these sort of widely dispersed dumb devices with software that's smart enough to do danger, but still really a bit hard to justify investing heavily in security. So when and if there's a dialogue about standard setting, it kind of has to level the playing field for all actors in this domain so that they're sort of sharing the cost, if you will, in terms of where that line is. I can't define that line, but that's kind of a reaction. If the standard setting process is approached with that idea in mind, it's more likely to get traction.
Good afternoon, Captain Michael Sanders, Air Force. So you guys kind of alluded to or started talking about this. You're all approaching this from a law enforcement perspective, which makes sense because you have those authorities already to go after these sorts of things. But as you mentioned, once we start talking overseas, or as we start talking, this becomes a bit more of a threat for physical damage. It's not just fraud and criminal or financial crimes. Where do national defense authorities start? Do you see that need to be integrated in some respect somewhere down the line? Not necessarily our primary aspect, but to have those as an option for going after some of these problems?
I guess it would be silly to take any tools off of the table if there is the right time and place to use them. I think this has always been the issue of threshold drawing, right? Of saying, so when do we trigger something that is in going from gray space to that area where we know that we use national defense authorities. I imagine there could be a scenario where you are dealing with a botnet that poses a significant national security threat where that might make sense. I'll leave it to policymakers with much larger titles to decide how those lines are drawn. But I don't think there's anyone who would say, we should never consider that option. I think the issue though is, where do we consider that option, and what are the reciprocal consequences of drawing a line, let's say, at a level below, actual conflict?
I'll give just one quick, really boring comment that's related. I think looking at our procurement processes is really important. Even though it seems like an indirect link, as we are engaging with new kinds of technologies around soldiers' bodies or other types of military equipment, sometimes we eliminate the older models and the redundancy measures, hoping for the best in terms of the technology just working. And that opens us up potentially to an adversary using our own heightened level of technology against us. And in the procurement process, thinking through all of the worst case scenario attack vectors and clearly weighing the benefits technologically and the risks technologically of corrupted inputs and compromise and being harnessed into a botnet, for example, with internet-connected exoskeletons that could provide tremendous benefit in terms of monitoring the health of the human body inside. But I don't know, if an adversary really wanted to hurt us, creating a botnet of exoskeletons on soldiers would be a really effective way to wreak some havoc. So part of the answer is in the boring procurement process, which I'm sure people who work in procurement do not agree with that characterization, so I apologize. But it's a very important part of the process, even though it may not be as initially exciting when you look at it.
Hi, I'm Bill Whitman from Air Force Research Lab up in Rome, New York. I'm a procurement, acquisition, contract attorney in cyber R&D and stuff.
I think you're very important.
I'll agree 100%, but I think your last comment, and then tied with the gentleman from Microsoft, points out, he said that transparency about what government really needs. The thing that I see in R&D procurement and contracting is that you have a tension between what the government may decide it really wants to have and achieve in either products, requirement definition, cybersecurity, and things like that, versus the acquisition and procurement policy that it's up to the commercial sector to propose solutions to our broadly defined government needs. So if we need a widget, we just say we want a widget that can kind of do this, but can't say exactly what we want the solution to be and build to this requirement. We have to rely on industry to come in and propose cybersecurity, propose baking it in. But then, of course, that's going to be driving up the bells and whistles and the cost, and then they're not going to get the contract. So how do you see, I guess, resolving that tension to actually get a good product that the government would need with all of those things built in that makes it safe and secure and meets the user's requirements?
Well, one short answer, and I admit freely I am not an expert on the procurement process, but to create minimum floors of security in every contract for every purchase of the U.S. federal government would be one streamlined way that we've used in the private sector in certain contexts as a physical security measure. So, for example, in landlord-tenant agreements, we say no landlord can have a term in an agreement that cuts off the heat in the middle of winter, because we just have a policy determination. So Congress could certainly intervene and put in a floor across all contracts in order to try to bolster the security mission as it's embodied in these agreements.
No, actually, I just thought that you...
Oh, no, I was going to say that we tried that a few years back when we put in the cybersecurity clauses in contracts, and it caused industry to go almost apoplectic, that we were saying that they needed to have certain security features on their computer systems in their businesses, and it got deferred and pushed off, and it was like the government was taking over the entire industry by saying you need to have passwords and basic security stuff. They went kind of nuts.
Yeah, but I don't have a lot of sympathy for the private sector on that one. This is a national security issue. We need baselines of security in all of our products across both the public and private sector.
Does Microsoft share that opinion?
I have no idea, happily. And I'm not an expert on government contracts, so certainly not with respect to Microsoft. But I will say one recent conversation I heard, I was kind of part of, was basically the larger contractors carrying the water for their subcontractors. If there's only one subcontractor and it's quite small, but it's a necessary and critical component, but at the same time they don't have the kind of scale to just dot all the I's and cross all the T's in terms of cybersecurity requirements. That kind of leaves the prime contractor holding the bag. And I think that's something that gets sorted out in the street every day, in a way. That's just an impression, not expert at all.
Because the problem, of course, is that if there's a vulnerability at any point in that supply chain, the whole supply chain's compromised. So you really need to have that floor across every single component. And there have been efforts at software bills of materials and other documentation efforts, at least, to try to identify and manage as new vulnerabilities crop up. But I think you just have to have that floor, or you're broken from the point of purchase.
And I think, fortunately, we're out of time. Please join me in thanking our panelists for a really thought-provoking discussion.